Hi, everyone. Welcome to another episode of the Ask Amity Show. In today's episode, we want to answer the question of why do I have to pay for a probate bond? Generally speaking, in California, when a person passes away and leaves behind a will, the named estate executor will need to probate it, especially if the estate is valued over $166,250. In other words, the executor should oversee payment of the decedent's debts before the beneficiaries receive their inheritance. One of the executor's specific duties may be posting a bond in California probate. So in California probate, a bond serves as an insurance policy for associated parties of the decedent in the event the estate's executor breaches a fiduciary duty while administering the estate. Oftentimes, the will writer has included a clause in their will that eliminates the need for a bond. However, even in these type of situations, the court may still require a bond in California probate.
So who gets the bond? So the personal representative, the executor, or the administrator of the estate must qualify for the bond. Qualification depends on the representative's net worth and creditworthiness. So that's a consideration when you're deciding who should be the personal representative. That personal representative should be able to be bonded. So the personal representatives who do not qualify could still actually find a solution if their attorney maintains control over the estate account. When the will does not waive a bond or the personal representative resides outside of the state, then bond is required. But you can also request a waiver of bond to the court, which must include a declaration that states, number one, the number of unsecured creditors of the estate and the estimated liability of them. Number two, all estimated tax liabilities. Number three, the amount of any known contingent liabilities. Number four, whether the estate is solvent. And lastly, the due diligence performed to establish the above information.
So how does a California probate bond work? In the event the estate's executor breaches a fiduciary duty, the beneficiary can pull the bond and obtain compensation for damages. Then the executor will have to reimburse the bond company up to the amount of the damages expended. So for example, we've had cases where bond really is necessary and really important. So in this situation, if somebody is appointed an executor, for instance, let's just do a scenario here. So if Jill is appointed executor of Bill's estate, which consists of several luxury condos and an estimated $10 million in stocks and bonds, and Mark is the sole beneficiary of Bill's estate, Jill obtained a probate bond from this company, and during the probate administration, she fails to pay the property taxes owed to Bill's condos in a timely manner. So then the County of Los Angeles comes in and commences foreclosure proceedings against Bill's condos. In this case, Jill basically breached her fiduciary duty because she failed to exercise ordinary care and diligence when managing Bill's home on Mark's behalf. As a result, Mark files a motion to have the bond company award him damages for Jill's breach, and the bond company awards damages to Mark and will seek reimbursement from Jill. So that's why, bonds are pretty important. It really serves as an insurance for the beneficiaries, just in case the fiduciary or the executor breaches their fiduciary duty. And in this scenario, Jill did breach her fiduciary duty by failing to pay property taxes. And so in turn, the beneficiary can claim damages from the bond company, and then the bond company would go after the executor of the estate.
So when is probate bond required? A California probate bond is required of all personal representatives to protect interested parties, including beneficiaries and creditors. However, the court does not require a bond in these following circumstances. Number one, the will waives the requirement of a bond. Or number two, all beneficiaries waive in writing the requirement of a bond, and the written waivers are attached to the petition for the appointment of the personal representative. So how to get a probate bond? In order to get a probate bond, the executor must first contact a local surety company to apply. Then the surety company will conduct a credit check on the executor, and the cost of the bond is proportionate to the executor's credit worthiness and the amount of the bond. The price of the bond depends on the value and the nature of the estate. When you do a probate case petition with us, we take care of all the bond process and make sure that you are either able to waive bond or that bond is applied for and is in effect throughout the probate process. If you have any questions about probate bond or probate, give us a call and we'll be more than happy to talk to you. We offer a free 20-minute consultation and look forward to speaking with you regarding probate. Thank you for watching and make sure you subscribe, and we'll see you in the next one.